Good morning, everybody, and thank you for braving the elements and coming over here this morning despite the considerable amount of snow out there. Unfortunately, yesterday's class was canceled, so what I've done is I have put up on the class website the continuation of the infringement lecture that we had last week. So if you want to know more about infringement, yesterday's lecture is up on the class website, and it takes you through infringement. Begins where we left off at the Adidas Puma lawsuit, and goes through all kinds of I think interesting stuff on infringement, and you can see how absolutely absurd it actually gets in some cases. But there's some really good information on there about what constitutes infringement and what doesn't, and I'm happy to field your questions, in the event there are any. I also brought in, apropos of our last lecture, some examples of that we discussed in class about patentable materials. Here's the famous Apple bag that we talked about that consists of about 39 separate patentable processes. And here are the prototypes of the run fins that Alex Slocum filed a provisional patent application for. You'll recall that we talked about how these devices look a little rudimentary and crude at the initial preliminary patent application stage and then evolve. So I thought I'd bring in the actual prototypes so that you can see that there's nothing to be afraid of here, and that actually examining how the prototypes were made will give you an example of perhaps something that you can use yourself. So let me pass these around, starting with the Apple bag, and you can have a look at them. Like I said, there's nothing to be afraid of when it comes to patenting items, and these are just some examples of some real live patents that exist, probably on the two extremes of the spectrum. You have, Apple, which is a $100 billion company filing patents for paper bags, and then you have Professor Slocum, who's motivated more by altruism than anything else, patenting his walking fins. Anyhow, I thought it was kind of fun. I wanted to talk today about another fun subject, which is patent trolls. Anybody know what a patent troll is? I mean, have you heard the term patent troll before? Everybody's nodding their heads. Yes, everybody's heard of patent trolls. I actually have an actual photograph of a patent troll. It was very difficult for me to find, but this is exactly, so if you want to know what a patent troll is, there is a photograph that's a drawing or a photograph of a patent troll. A patent troll is any person or company that obtains the rights to one or more patents in order to profit by means of licensing or litigation rather than by producing its own goods or services. In essence, it's a pejorative term that is used to describe a person or company who uses predatory methods in order to extort money from people who allegedly infringe on patents that they claim to own. So patent trolling is a pejorative term. And the key to understanding patent trolls is that they exist for one reason and one reason alone. That is to extort money from people who use processes or devices or inventions that they claim ownership to. For instance, I could maybe file an application for a patent on the method of flight. And if I was able to get that through the United States Patent and Trademark Office, the way I would use that if I were a patent troll would be to not sue Boeing, because Boeing can defend themselves against me, but maybe I would sue everybody who's ever ridden on a Boeing aircraft. And I'll explain how that works. But that's the absurdity of the patent troll situation. And that is not, as I will show you, much of an exaggeration over what actually goes on. And the reason I've incorporated this patent troll lecture into this series is because I think that other than protecting your own intellectual property, the other way that you are most likely to come in contact with the legal system as it relates to intellectual property is being the victim of a patent troll. So these businesses are usually shell corporations that file a bunch of crazy vague patents, like the method for flying on an airplane. They use these vague patents to sue companies that are small enough not to be able to defend themselves, or in many cases sue individuals who obviously don't have the funds to defend themselves. And the key is these companies don't produce anything. They have no redeeming social value, although there is a counterpoint to that, because while they may produce nothing of any value, sometimes they do altruistic things with the money that they obtain from patent trolling. But for the most part, 99 9/10% of the patent trolls out there are just trying to victimize and intimidate and harass and extort money from others. Surprisingly, a lot of these companies are all incorporated in East Texas. There is a unique thing about East Texas, and I think it is the reason why these patent troll companies were all formed there. Several United States District Court judges who are on the bench in East Texas and who receive an offer, in whose courts these cases are filed, have family members who are attorneys who prosecute patent troll cases. And there are studies done on these particular justices that sit in Texas where their family members have brought suit, and these judges are the least likely to dismiss these types of lawsuits. So you have federal judges sitting on the bench in East Texas whose sons run law firms that do nothing but file lawsuits on behalf of patent trolls. And the thing about it that you need to remember is if you're sitting here in Massachusetts, and let's say, for example, you're using Wi-Fi, and one of these patent troll companies in East Texas decides to victimize you because they have a vague patent out there, which they claim protects or gives them the right to the technology that is Wi-Fi. And you're sitting here in Massachusetts, you have to defend the case in East Texas. And these cases usually cost $2 or $3 million to, even the frivolous ones, to defend. And so what people do is they pay these patent trolls off. And that's why patent trolls have the reputation they do. So these shadowy firms make money by threatening patent lawsuits rather than creating useful products. And that's the other thing. They oftentimes don't follow through with the lawsuit. They actually send a letter out and says, hey, I see that you've been using an X-ray. You've been using an X-ray machine. Well, I hold the patent on X-ray machines, and I want you to pay me X number of dollars, or I will file this lawsuit in the East District of Texas against you. And what do you do if you're a small company or an individual or an academic? Oftentimes what they do is they pay these people off, and that's why they exist. The typical cost of defending against a patent infringement suit is about $1 million before trial, and as much as $3 million to take the case through the courts. And because these costs are high, and because the risks and predictability of the United States court system is so variable, in order to avoid the whole problem with litigation, oftentimes people just enter into settlements. This has been studied. Lawsuits brought by patent assertion companies, that's what they're called. I call them patent trolls, but they call themselves patent assertion companies, made up 61% of all patent cases in 2012. And from 2009 to 2013, companies like Apple was a defendant in 171 lawsuits brought by non-practicing entities. Hewlett-Packard, 137, Samsung, 133, AT&T, 127, Dell. And these are the big companies. These are the ones that can defend themselves. This doesn't even approach the numbers that have been filed against people who are unable to defend themselves. Patent troll litigation, which was once mostly confined to big companies, has now spread because the victims are easier to intimidate and to extort money from. So they've now spread to small firms and individuals. In 2005, patent trolls sued 800 small firms, and that's defined by firms worth less than $100 million in annual revenue. By 2011, that had grown to 2,900 lawsuits. By 2014, a Price Waterhouse study concluded that non-practicing entities accounted for 67% of all lawsuits filed in the United States. That's an enormous, enormous number of lawsuits. When you look at it, that would suggest that at least 33% of all lawsuits filed in the United States are filed in good faith. So only a third of the lawsuits filed involving intellectual property are filed in good faith. 2/3 are filed in bad faith and constitute what most would call frivolous lawsuits. The other corrosive effect that patent trolls have on society in general is that they reduce research and development. They stifle innovation. They hurt the spread of scientific knowledge, because oftentimes what has to happen is companies, large companies, have to devote a significant amount of money to defending these lawsuits. Here, big companies, according to this study, had to invest $211 million, less than firms having won patents against a troll. So it really affects basic research in large companies. Catherine Tucker at MIT studied venture capital investing related to diagnostic imaging, the diagnostic imaging industry. What she found is that lawsuits from frequent litigators, patent trolls, were responsible for a decline of $22 billion in revenue in venture investment over a 5-year period. That's an enormous amount of money that's being sucked out of research and development, that's basically going into protecting against patent troll litigation. Imagine how much research you can do for $22 billion. So patent trolling has a real corrosive effect on the spread of knowledge and scientific research, development, and innovation. This is her study, in case you're interested in it. It actually is very thorough study. Another study in 2017 by the London School of Economics by these professors Fang, Joss, and Xavier found that the reason for patent trolling, or how patent trolling is made possible, is because of problems with the U.S. Patent and Trademark Office. So how does this problem of patent trolling occur? Well, remember that all patents are defined by the claims section. We talked about that. The heart of a patent is its claims, which is a numbered list of exactly what the technology will do. And an important part of the patent examination process is the give and take that occurs between the patent examiner and the inventor. Remember, I talked about the dialogue that occurs between the inventor and the patent examiner. The inventor will want to have as broad a patent as possible, and we talked about the University of California at Berkeley's patent in the CRISPR case. But that's just one example. It happens in every single case. So you enter into this dialogue with the patent examiner about the claims and the scope of the claims, and whether or not your invention can actually do what you claim it to do. If you have a good patent examiner, the patent examiner will make sure that your claims are limited to what your invention can actually do. But if you have a bad patent examiner, you'll be able to sneak things through the patent office that shouldn't sneak through because the patent examiner doesn't push back, okay? And it's their job to push back, but oftentimes they don't. So patent examiners don't just decide whether or not to approve a patent. What they really do is they shape the scope of the claims to make sure that those claims only cover what the invention can do. What these folks at the London School of Economics found is that examiners who demand the fewest changes to patent claims account for a disproportionate share of patents that ultimately wind up in patent lawsuits. So they literally studied all of the patents, a group of patents that were approved by the USPTO, and they looked at the dialogue that went on between the examiner and the inventor, and how many patent examiners required changes to the scope of those claims. And they found that the examiners who approved patents that had the fewest change requests are the ones that ultimately ended up in court. And it makes sense. If a claim is vague or subject to more than one interpretation, you're more than likely to have a dispute involving it. So if the examiner is doing their job of vetting the patent claims, then it would be expected that there would be more claims, changes to the claims requested. And most of the changes involve qualifiers like shortening the claim or making it longer or making it more specific. And so Feng and his co-authors realized that the change in patent claim length could serve as sort of a proxy or an avatar for how thoroughly a patent examiner was doing his or her job. And so the study found that patents reviewed by examiners who are one standard deviation more lenient, think about that, just one standard deviation more lenient, that can be one additional claim or a request to change a claim. One standard deviation more lenient than the others were 63% more likely to be purchased by a patent troll company and 64% more likely to be involved in litigation. So what companies do is they go out there and they search the USPTO lawsuit website for vague patents, patents that have claims that aren't specific enough. And they buy those patents, they license those patents. And then they become part of the portfolio that they use to extort settlements from innocent people like you. So the issue basically stems from the fact that the patent office can't check whether the people filing a patent are in fact the original creators of the technology or not. It's basically a manpower problem. So let me give you some examples of some patents that have actually snuck through the US Patent and Trademark Office in case you think that I'm exaggerating this. Here is a patent that was granted in 2002 for how to swing on a swing. Now, we talked about whether things are in the public domain or whether things are part of public knowledge or prior art. I mean, I think everybody in this classroom knows well enough that swinging on a swing is, on its face, not technology that's patentable. We've been kind of swinging on a swing for a long time. Yet, in 2002, the United States Patent and Trademark Office granted a patent for swinging on a swing. And this technology, this patent, was then used by patent trolls to extort settlements from others. Here's the actual figure that was submitted with the patent application for swinging on a swing. And this is what got through the U.S. Patent and Trademark Office. Give you another example. The method for exercising a cat. This actually made it through the United States Patent and Trademark Office. You can look it up. It's patent number 5,443,036. And I thought I'd pull the abstract out for you. A method for inducing cats to exercise consists of directing a beam of invisible light produced by a handheld laser apparatus onto the floor or wall or other opaque surface in the vicinity of the cat, then moving the laser so as to cause the bright pattern of light to move. Has anybody played with a cat before and used a light to play with a cat before? Well, if I was the patent examiner on this, and I hope that if any of you were the patent examiners on this, you would have turned this down. But the patent examiner in this case didn't turn it down. It actually made it through the Patent and Trademark Office. Here's, by the way, just so you know I'm not making this stuff up, this is literally the abstract. This is the claim. These are the claims that were made for this invention. Directing an intense, coherent beam of invisible light. Selectively redirecting said beam. Actually, a pretty fair job of writing a claim about nonsense. I have to admire the draftsmanship, to tell you the truth, and it's a very good example of how to write a claim. Unfortunately, in this case, it's a claim about nonsense. But that's actually the claims from the patent application. And in case you were wondering or wanted to see the drawing that went with it, here it is. Made it through the Patent and Trademark Office. I used to watch my mother do that all the time with the cats. I had no idea she was violating somebody's intellectual property. So the result of this is having a patent does not really give you protection from other people using your idea. What it does is it gives others the right to attack anyone who infringes on your patent, even if you shouldn't have been given the patent in the first place. And that's the problem with the system. If you want to prove that the patent was not valid, then the only way to do that is fight the lawsuit. Go to the Eastern District of Texas, hire lawyers, file the opposition to the lawsuit, the answer, do the research on prior art to show that the patent was not valid. In other words, you have to do all the heavy lifting to show that the claims are not valid. And that's tremendously expensive work. And so what do people do? They capitulate. Here's some examples of things that in the Eastern District of Texas, people have been sued for using the Google Play Store. Not inventing the Google Play Store, but using the Google Play Store. What the troll did in that case, and the individual received a letter in the mail from one of these companies saying, by uploading your invention, and this is somebody that invented had actually written a lot of code, software, to invent an app, which they patented, and which they then sought to monetize by uploading to the Google Play Store. Okay, so this is an inventor like you out there who's done an awful lot of research and a lot of code writing, came up with a wonderful idea, was able to fix it in tangible form by drafting the software. They were able to get Google to agree to allow them to load it up on their Google Play Store, which they did in the hopes of selling a bunch of these apps. And instead, what they get in the mail is a cease and desist letter from a patent troll saying, we own the technology for the Google Play Store. Now, they'd never written a line of code in their life. They didn't invent Google, obviously, that's not what they're claiming, but they claimed that they owned a patent which they had purchased, a vague patent that made it through the US Patent and Trademark Office, which they argued was the equivalent or was the method or process that the Google Play Store is based on. They didn't sue Google because Google would land on them like a ton of bricks. Google has the assets and the inclination to defend these cases vigorously. What they sued is some poor guy, some poor inventor that came up with an idea, patented a great app, but then he got sued. What did he have to do? He had to go to the Eastern District of Texas. He had to file an opposition, an answer to the lawsuit, and defend the case. He was in court for 5 years. 5 years defending this case. Ultimately, he prevailed. In fact, you can go on YouTube, and there's a whole series of interviews that he had done about his experiences. And it's really a telling tale, how someone who really is creative and had a wonderful idea, who just tried to monetize their idea, was the victim of an extortion scheme, a legal extortion scheme by these folks. Other examples, using scanners. Anybody use a scanner here? Well, watch out. You may end up getting a cease and desist letter. How about using Wi-Fi? These are all examples of lawsuits brought in the Eastern District of Texas. Using a Microsoft product. This is not Microsoft suing. These are people that claim to own patents on technology on which these things are based. Patent troll, here are the two biggest offenders. Unilock and Marathon Patent Group. Marathon Patent Group is actually on the NASDAQ. They are a publicly traded company that literally builds, makes, invents nothing. And because they build, make, and have invented and sold nothing, what happens to the poor inventor who went to the Eastern District of Texas and won their lawsuit against the company? What do they get? They get nothing. Because these companies are all mostly just shell companies. In fact, there's one building in Austin, Texas, which is basically a mail drop for dozens of these troll companies. And you go there and you knock on the door, there's nobody there. There's literally just a pile of mail up in front of the door. These companies own nothing, they sell nothing, they make nothing, they have no assets. And many of them are actually set up in order to conceal the identities of the owners of the companies. I think probably some of you have heard about non-disclosure agreements being in the news recently. Well, these companies typically use non-disclosure agreements. You may wonder, well, why don't I read about these things in the newspaper? Why don't I know about these patent trolls? I mean, I've heard the term. One of the reasons why you haven't heard about them is because they all use non-disclosure agreements. So when they enter into a settlement for a few dollars with a inventor to get them off the inventor's back, what they all require as part of that settlement is a non-disclosure agreement. So the inventor who has won their lawsuit or has entered into a settlement to just dispose of it as a nuisance is prohibited from talking about it. They're better at writing non-disclosure agreements than they are at inventing things. But that's how they hide from plain view. So, solutions. What solutions are there? When the America Invents Act was passed in 2013, when it was passed in 2011 and signed into law eventually in 2013 by President Obama. President Obama wanted the Congress to go further and to take steps to eliminate patent trolling. And I thought this was a pretty good quote. What President Obama said is, they don't actually produce anything themselves, they're just trying to essentially leverage and hijack somebody else's idea and see if they can extort some money out of them. And so what the president did is then ordered the United States Patent and Trademark Office to be more careful about the inventions that they approve, and especially to push back on the claims that inventors make in their inventions. And President Obama also asked Congress to pass some laws. That same year, Congress enacted legislation to reduce the incidence of patent trolling. It's called the Patent Litigation Integrity Act. This is what gives lawyers a bad name, because while it was proposed by Orrin Hatch in the Senate, when the bill made it over to the House, it was killed by Harry Reid, who was beholden to the Trial Lawyers Association. He received an awful lot of donations from the Trial Lawyers Association, and in return for that, Harry Reid killed this legislation. And so we don't have, at this point, really any effective federal legislation protecting inventors from patent trolls. The Federal Trade Commission did something interesting. While Congress was killing legislation that would have protected everybody, the FTC brought a consumer protection lawsuit against a patent troll for deceptive sales claims and phony and illegal threats. And the FTC found that the defendant MPHJ, which is just another one of these shell companies, patent troll companies, has sent letters to more than 16,000 small businesses threatening patent infringement lawsuits if the companies did not comply with its demand for a licensing fee of $1,000. You can see these are real boilerplate operations. I mean, you can go in your basement, and as long as you have a copy machine and a computer, you can send out 16,000 letters to unsuspecting businesses demanding or trying to extort money from them. And, $1,000 times 16,000, you can do the math. Anyhow, though, the FTC got after these folks, and they fined the company $16,000 per letter that its attorney sent out. Did they pay it? No, because the company had no assets, but at least it stopped them. So what has happened since then, I don't know why that happened, but what has happened since then is a number of states, including Massachusetts, have gotten into the act. And what they've done is they have now passed consumer protection laws. Here in Massachusetts, for instance, you have the Massachusetts Consumer Protection Act, Chapter 93A, which we have used in my law firm as a battering ram against patent trolls. And basically what it says is the use of false or deceptive trolling techniques violates the consumer protection laws. And in Massachusetts, that subjects the violator to double or treble damages, including attorney's fees. So, and there's also pending in Congress legislation that would enable people to defend patent troll lawsuits in the venue where they live. So one of the things you can do now in federal court is if you get sued by somebody in the Eastern District of Texas, is you can move to have that case removed to where you live, thus making it a lot easier to defend. And as time goes on, hopefully there'll be more legislation and more ways to combat patent trolling. Now, I've looked at every article. There are articles out there that say patent trolling helps the manufacturing process and keeps the price of goods down, but as you follow the money in those things, you find out that most of those studies were written by people that were paid to write them by patent trolls. So I personally can't find any good things to say about patent trolls or patent trolling. It inhibits innovation, it stifles competition, it's a tremendous burden on inventors, and the only thing that you can do is be on the lookout for them. And know that in Massachusetts, at least, if you're the victim of a patent trolling scam, that you do have some consumer laws that are not available on the federal level that could very well protect you. So that's my thing on patent trolls. Any questions? Tomorrow's our last day of class. I'm going to tell you the story of, finally, of graphene. We're not meeting on Friday, so tomorrow is free flour bakery goodies. And I'm also going to ask you to complete a survey, take a little time in the class to complete a survey for us to see what we're doing right, what we're doing wrong, and what you think we should do for the future. So if there are no questions, that's all I got for today. Thank you, thank you, thank you.